The people of the state of Michigan versus Ashley Page Barnhill. And this is the People's Emergency Motion regarding bond.
Thank you, Your Honor. We got a very disturbing voicemail from the father of this child, who is also the victim in this pending case, really begging for somebody to do something because CPS wasn't doing anything. And
that is not a surprise.
Correct.
Were they called?
Yes,
Okay.
Yes. And what I'm asking for fundamentally here, Judge, is that you revoke her bond. And I will go through all of the reasons I think that is absolutely necessary in this case, not only to keep the community safe, but to keep these children safe. Because this defendant is a danger to not only her children, but to any child. Your Honor, I actually remember that case when I was your docket prosecutor a few years ago. And why do I remember that case, Your Honor? It was a CCW, but there was another component to it. Because the victim's, the child's father, right, who's the victim in this case.
Was the victim there?
Yes, because he called police and said, this defendant tried to hit me with her car. We couldn't proceed on that count because he didn't want to get her in trouble. You know, he wanted to work things out with her. She was 12 weeks pregnant at the time. So she's driving a car allegedly, trying to hit the father of her soon-to-be child, which is the victim now in this case. And how does that argument start, Your Honor? Over marijuana, over weed. And I'd like to point out that I read her the PSI for that case, and she told this court and the PSI writer, oh, I stopped marijuana. I stopped all of that when I found out I was pregnant. Incorrect. By her own admissions, at 12 weeks pregnant, she's trying to get marijuana and ingest marijuana. So now let's talk about the case that she's currently on bond for. Okay, this is a child abuse third case. And how does this start about? The child, and not just a child, we're talking about a 12-month-old baby, right? So she gets into it with the father of this child. He's making some sort of cake for someone's death. And she's mad that he's spent money on that cake, probably because it's taking money away from, I don't know, maybe some illicit substances. So what does she do, Your Honor? She throws the cake to the ground, and then he grabs her phone, and in an effort to get her phone back, she uses the 12-month-old baby as a bargaining chip, grabs that baby so tightly around the arms that it leaves red marks on the arms of this 12-month-old.
Can I interrupt you? Was she with the victim? Because there's a no contact order. Is that how she knows about the cake and throws the cake?
If there was a no contact order as part, so the cake incident is those facts are why she's on bond right now, to Your Honor. And I don't believe there was a no contact from the CCW.
Okay.
Does that make sense?
Yes.
And he takes the kid, and what does she do in response, Judge? She takes 2 knives, follows him, tries to get in his face, and then begins stabbing the walls. While the child is still there, over what? Money? I mean, that's so what I'm saying, Your Honor, is that is incredibly dangerous behavior, right? We are seeing an escalation. We're seeing this pattern of violence. We're seeing this pattern of her putting herself, her needs, her wants above children, above her own child, and above a baby. Between June 6th and June 7th, the child is now 14 months old, was admitted to the hospital for a marijuana overdose, okay? And this 14-month-old was asleep for 15 hours, which Your Honor knows well with children. That is incredibly dangerous. They need to eat every 3 to 4 hours. And the fact that that baby is completely asleep for that amount of time is very dangerous. And so how do we find out about this? Well, it's not the defendant telling CPS. Nope. It's not them telling the father. Nope. In fact, there's kind of sort of this cover up where the dad is saying, when can I come get my child? And on that Saturday, grandma is saying, oh, we might have a birthday party the next day. Oh, I don't know if she can come home while she's in the hospital. Grandma, right, who this defendant had told you can be the supervisor for this child, right, when she has contact with this child. On June 12, 2026, she told CPS that she had expressed to both the baby's father, right, and this defendant, she'd already expressed to them that she no longer wants to supervise the visits because she is too old and has a life of her own. When they discussed with her the marijuana, she advised she uses edibles and her estranged husband smokes. CPS asked her if marijuana is kept in the house. She said it's in her bedroom. They asked if any could have dropped that the child could have gotten into or been in her bedroom. She said it's possible because there are always a lot of kids running around the household and she can't keep up. She stated everyone uses marijuana and she treated the situation as less significant than it was. So I'm not sure what kind of weed funhouse we've got going on here, but it's completely unacceptable. They interviewed her on June 8th, right when the child had gotten out of the hospital. And just so we're clear, Judge, Grandma actually told this defendant, you gotta take her to the hospital. Why? This 14-month-old is lethargic. Her eyes keep rolling back in her head. She's not able to walk and she refused a bottle. Where's the defendant? Where is she to notice this? Why isn't she taking this child to the hospital? Why doesn't anybody care?
This is bond conditions. On the other file, she's not to be in the presence of any third parties who have marijuana. CPS is involved now?
CPS is involved, and I want to talk a little bit about that next.
Okay.
So they did actually meet with mom, defendant, and grandma last night. Mom is refusing, defendant is refusing to adhere to a safety plan. They said, please take this child, put this child with a relative. And what does this defendant do? She says, I'm not giving the child back to the dad. Nope. Here are 2 names of relatives that the kid can stay with. Doesn't provide a last name. Provides an address. It's the same address as grandma. Grandma who has told CPS, this is too much for me. Grandma who has said there's marijuana everywhere in this house.
Now let me interject that my order of April 15th says very specifically, ma'am, because you just put up your hands like this, like something's wrong here, and I'll wait to hear from you, but it says, follow all family court orders, recommendations, and all recommendations of CPS. That would be a recommendation from CPS is what you're telling me, is that correct?
Absolutely.
Thank you.
Absolutely. She's not complying with the safety plan because guess what? They said put the child with a relative. And you know what? Where was the child last night? Still with mom, still with grandma. It's not with somebody else. And also, interestingly enough, they asked her, hey, will you take a drug screen last night? She says, no, I'm not taking one. She says, I'm taking one tomorrow, which I guess, I don't know.
Did she take one?
She did not.
Okay, guess what we're gonna do right now? We're gonna take a break. Ma'am, you're going downstairs for a drug screen right now.
I asked that an officer.
I'm gonna just ask the deputy. Can we have a deputy escort her down to probation for a drug test? Thank you.
Probation.
Thank you. And you administered a drug test. Was it positive for anything?
It was negative for amphetamines, cocaine, fentanyl, methamphetamines, opiates, oxycontin, and tramadol.
However, you don't test for marijuana anymore?
We don't have those on our instant test, no.
The sample that she gave, can that be sent?
This cannot. We could urine test her and send that one out, or we could send her to AberHealth and have her test today.
Oh, she's not going anywhere, I think, but we'll see. But she could give another sample and we can test
We can
that.
do a urine sample and send
All
it
right.
out to her.
Appreciate doing that. Thank you very much. Yes.
And Judge, I think there was I don't know if the court received an email from probation downstairs regarding a statement this defendant made downstairs about, we'll see what happens. We'll see what's on the test. So it's not like she's even denying that something would come up further. She refused to be tested yesterday by CPS. You know, of course, I'm conjecturing at this point, but if she really had nothing in her system, what would she have to hide? For all those reasons, I'd ask that you revoke bond. If you are inclined to not revoke bond, I have a whole list of conditions I would ask that Your Honor put on, like that she immediately hand that child over to CPS immediately.
Where is the child right now?
I presume with grandmother at the house.
So father was denied picking the child up?
Correct.
Okay.
Correct.
Okay, well, let's not get to those requests right now. We hear from the counsel and defendant. Sir, if you could come up to the podium with your client. Ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and the penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any illegal drugs, marijuana, alcohol yesterday or today?
You want me to be honest? Yeah, I
Oh,
thought
yeah, I want you to be honest. Otherwise, it's
I'm sorry.
perjury.
I thought I don't know what I was coming here today, but I was scared and I smoked yesterday. Someone handed me a joint and I hit it.
And you understand that's per probation and bond conditions, no marijuana, not to be in the presence of it, not to use it.
I am aware, Your Honor. Yes.
This courtroom hearing involved Ashley Page Barnhill, a Michigan woman accused of child abuse, who appeared before the court after prosecutors filed an emergency motion seeking to revoke her bond. What began as a bond hearing quickly developed into a heated discussion about child safety, drug use, parental responsibility, and Ashley's repeated failure to comply with court orders. Prosecutors argued that Ashley represented a danger not only to her own children, but to any child placed in her care. The defense attempted to portray the situation as a misunderstanding centered around marijuana exposure rather than intentional abuse. However, after hearing testimony, reviewing the facts and questioning Ashley directly, the judge ultimately decided to revoke her bond, place strict restrictions on her future conduct, and ensure that her children remained in the custody of their father while further investigations continued. The hearing began when prosecutors informed the court that they had received a disturbing voicemail from the father of Ashley's child, who was also the victim in the underlying criminal case. According to the prosecutor, the father was desperately asking for help because he believed Child Protective Services had failed to take sufficient action to protect the children. This prompted the prosecution to file an emergency motion requesting immediate bond revocation. Prosecutors argued that Ashley posed an ongoing danger to her children and that allowing her to remain free created unacceptable risks. They maintained that the issue was not simply about a single mistake, but rather a continuing pattern of reckless and dangerous behavior involving violence, poor judgment, drug use, and neglect. To support this argument, the prosecutor reviewed Ashley's history with the criminal justice system. He recalled an earlier case involving a concealed weapon charge that also included allegations of violence against the father of her child. According to police reports, Ashley allegedly attempted to hit him with her vehicle while she was approximately 12 weeks pregnant. Although charges related to that incident were never fully pursued because the father wanted to work things out with her, the prosecutor argued that the event revealed a troubling pattern. He pointed out that the dispute reportedly started over marijuana and contradicted Ashley's earlier claims that she had stopped using marijuana immediately after learning she was pregnant. In the prosecutor's view, this demonstrated a long history of dishonesty and poor decision-making surrounding drug use and relationships. The prosecutor then shifted attention to the current child abuse case. According to the state, the incident began when Ashley became angry with the child's father over money he spent on a cake for a memorial event. During the argument, she allegedly threw the cake on the ground. When the father grabbed her phone, Ashley reportedly responded by using their 12-month-old child as leverage. Prosecutors claimed she grabbed the baby so forcefully by the arms that visible red marks were left behind. The situation then escalated further when Ashley allegedly armed herself with 2 knives and pursued the father while the child was still present. According to the prosecution, she began stabbing at a wall during the confrontation, creating an extremely dangerous environment for everyone involved. The prosecutor argued that these actions reflected a disturbing pattern of putting her own emotions and desires above the safety and well-being of her child. The court then learned about an even more alarming incident involving Ashley's youngest child. Between June 6th and June 7th, the 14-month-old child was admitted to a hospital after suffering what was believed to be a marijuana overdose. According to the prosecutor, the child slept for approximately 15 hours and exhibited symptoms including lethargy, difficulty walking, rolling eyes, and refusal to eat or drink normally. Medical personnel considered the situation extremely dangerous because young children require regular nutrition and hydration. Prosecutors argued that the child's condition could easily have become life-threatening if medical attention had been delayed further. One of the most troubling aspects of the case according to the prosecution, was how the overdose came to light. The prosecutor emphasized that neither Ashley nor her family immediately informed the father or CPS about the hospitalization. Instead, there appeared to be attempts to conceal the seriousness of the situation. While the father repeatedly tried to find out what was happening and asked when he could see his child, family members allegedly offered vague explanations and avoided disclosing the full truth. Prosecutors portrayed this behavior as evidence that the adults involved were more concerned about protecting themselves than ensuring the child's safety. Attention then turned toward Ashley's mother, who had been approved as a supervisor for visits involving the child. Prosecutors described her as an inappropriate caregiver and raised serious concerns about the environment in her home. According to statements gathered by CPS, the grandmother admitted that marijuana was